On May 21, 2024, Edric Faust was indicted by an Athens-Clarke County grand jury on charges of malice murder, felony murder, and aggravated assault in the 2001 strangled, stabbed, beaten, and death of 23-year-old Tara Louise Baker. Ms. Baker, a first-year law student at the University of Georgia, was found dead inside her burning apartment just one day before her graduation, a case that remained unsolved for over 2 decades. The case was heard in Clarke County Superior Court before Judge Lisa Lott, nearly 23 years after the initial discovery of the crime. The case remained cold for 23 years, until advancements in forensic technology led to Mr. Faust's arrest in May 2024. Following a lengthy investigation aided by the GBI's cold case unit, the trial commenced in early 2026. Prosecutors claimed DNA from a resubmitted 2001 rape kit matches Mr. Faust with a statistical certainty of 1 in 800 quadrillion. On February 2, 2026, District Attorneys Kalki Yalamanchili and Chris Bolden objected to the defense attorney Ahmad Cruz's attempt to introduce information regarding the victim's past and a witness's statements without following proper legal procedures.
Since I had made opening statement,
Pull that microphone towards you. Thank you.
that I would object since I had made the opening statement, but since Mr. Yalamanchili had made the 412 arguments in the past that he would handle.
All right. Thank you. Go ahead, sir.
Your Honor, as the court's aware, as the state's aware, if Mr. Cruz wasn't aware before we started all the pretrial motions in this case, he ought to be aware now. Making reference, whether it's a statement made by some other witness, whether it's elicited in direct examination, cross-examination, or any other method, to a relationship between Ms. Baker and anyone else that was not noticed by the defense as a 412 act is prohibited by 24-4-412. I'm not sure how much clearer the statutory language could be, not sure how much clearer the court could possibly have been in its instructions, but whether it's Mr. Cruz making reference to a statement that some witness made during an interview with law enforcement, or whether it's Mr. Cruz eliciting the testimony on direct examination or cross-examination, it is all prohibited by the rule, which Mr. Cruz has violated now for the second time in his opening statement. It does not matter. It does not matter one bit whether or not Chris Melton said that in an interview to law enforcement for the analysis of whether or not it is admissible and the methods that must be adhered to if the defense intends to admit it in any way, shape, or form, Judge. And so this is the second time before we've called the first witness to the witness stand that Mr. Cruz has violated 412 in what seems at this point to be an intentional pattern to try to work his way around the laws and rules of the state of Georgia as it relates to admissible evidence in cases involving allegations of rape and aggravated sodomy, Your Honor. So again, at this point, I don't know what the remedy is that the court wants to enact, but obviously telling Mr. Cruz not to do it isn't effective because he's not listening and he's not following the court's orders.
Thank you. Cruz. Any response?
Absolutely. I'm actually blown away and in shock that the state is taking this statement to be a 412 argument. Our theory of this case is that Chris Melton committed this crime. Chris Melton's statement, when he's confronted with DNA that he already knew was present, that she was with someone else, it has nothing to do with us trying to get around 412. That statement is for the sole purpose of showing his consciousness of guilt. He knew this information in 2001. He's told the exact same information in 2024. And his response isn't, oh, my girlfriend, I can't believe this happened, you guys better find her. His response is just simply to say, oh, well, let's believe her. It means she was with somebody else. There's no evidence that I intend to present that Chris Melton knows about Ms. Baker's sexual history. There's nothing I can intimate that Ms. Baker knows, that Mr. Melton knows about Ms. Baker's sexual history. The purpose of that statement has nothing to do with her character, under 24-412, her sexual character. The purpose of that statement is to show Chris Melton's response. When he's presented with some evidence, he gives a response that's inconsistent with the person that is innocent. So this isn't a 412. I understand the state may not like what I present, but that does not mean I have to preview every single statement I have to them so they can prepare their case. This is open statement show. I respect the court. I do anything for this court. I've told the court that multiple times. This is not a 412 argument. This is Chris Melvin, who knows nothing about this Baker's sexual history, being confronted with a piece of evidence and making a statement that shows consciousness of guilt in our court. This has nothing to do with sex.
All right, thank you. As this court has stated multiple times, this is the second time today, multiple times during hearings, that there is a process that must be adhered to in order to get the appropriate permission from the court to introduce statements, evidence that another party objects to. In this particular case, it is a 412 motion. We have talked about this over and over again. What I have said over and over again is that the defense has failed to file a motion under 412. The state did. The defense has failed to file a motion, and I've said many times that if the defense files a 412 motion, even though it's not timely, the court will consider it. There has been no motion filed. Mr. Cruz, you've been made aware many times that you are not to bring in this kind of statement. I mean, I realize I have said several times today that opening and closing arguments of the attorneys and arguments are not evidence, and I'm going to say it again when the jury comes out. But you've been told many times that in order to, I'm talking now, Mr. Cruz, thank you. You have been told many times that in order to present statements like that, ask for the admissibility of evidence like that, you have to file the proper motion. And the court may consider it even though it's not timely. As I just stated 10 minutes ago, I do find your statements to the jury to be avenues to circumvent 412. And it is not appropriate. I'm finding you in contempt of court. You have had the opportunity to explain yourself, and I'm fining you $1,000. And you are to present that $1,000 tomorrow morning by 9 a.m. Put it into the registry of the court. And that is my sanction for continuing to not abide by this court's orders. I don't know how many times we're going to have this, but it really can't happen again.
Judge Lisa Lott held Mr. Cruz in contempt due to violation of Rule 412. Under Official Code of Georgia 412, it is inadmissible to bring up the victim's past sexual history or reputation during a trial. If the defense wants to use a victim's past sexual behavior as evidence, they must file a specific motion and have a hearing before the trial. District Attorney Kalki Yalamanchili affirmed that Mr. Cruz was trying to evade the code for the second time before they called the first witness to confirm his allegation. While Mr. Cruz offered a proffer of evidence, arguing that the line of questioning was intended to impeach the credibility of witness Chris Melton regarding inconsistent DNA-related statements, the court found this argument insufficient to override the statutory protections of the victim. Under Official Code of Georgia 4, the court has the power to summary punishment for contempt of court and violations of court orders. After Judge Lott warned Mr. Cruz in the pretrial to stop circumventing her orders, Mr. Cruz continued the same line of argument, leading to the immediate contempt. A fine of $1,000 was imposed against Mr. Cruz, payable to the clerk of court. On February 4, 2026, following the contempt ruling, the defense formally moved for a mistrial.
Yes, sir.
And I'm moving for a mistrial. We raised a objection to lack of foundation. The case is Monroe v. State, 340, Georgia Appeal, 373, 2017. It provides that the Honorable Court has wide latitude to admit demonstrative evidence, and the burden is on the party offering demonstrative evidence to lay a proper foundation establishing a similarity of circumstances and conditions. Although the conditions of the demonstration need not be identical to the event at issue, they must be so nearly the same in substantial particulars as to afford a fair comparison in respect to the particular issue in which the demonstrative evidence is directed. Further, experimental or demonstrative evidence, like any evidence offered at trial, should be excluded if it's probative value and the case goes on. But we emphasize the language that we stated. Your Honor, we raised a lack of foundation objection. Your Honor alleviated the state of their burden to prove any type of substantiality between the tests that Mr. Agent Grove, is that correct? Engineer Grove conducted and allowed the state to introduce this demonstrative. Once the bail is wrong with the jury, it cannot be unwrong. As we've said throughout this trial, Mr. Foster's defense has been handcuffed. The state has had free reign. It's to the point where our objections aren't even acknowledged. So, Your Honor, based on Mr. Foster's due process rights, violation of Mr. Foster's due process rights, and the entry of this exhibit, we would ask that the Honorable Court grant our motion for mistrial.
Thank you. Mr. Yalman-Chile, any response?
Your Honor, the foundation for the admission of the exhibit was laid. We haven't gotten to any of the questions as far as, what testing was done by Mr. Grove. We went through his qualifications. So, one, the motion is untimely, but even fast forwarding for the purposes of, and I would just note for the record, the only thing that's been displayed to the jury is a picture of the exterior of 160 Fawn Drive. So, but just fast forwarding a little bit, Your Honor, Mr. Grove received information. He tested certain things that were part of the theory as far as how the fire began in this case, and those are contained in the report. I would also note for the record that Mr. Cruz had an opportunity to review this PowerPoint last night in its entirety. He did not raise any kind of issue with the court prior to bringing the jury in. It's certainly, one, it's not even improper, but two, it's not grounds for
Mr. Cruz, you got Mr. Cruz, I'm going to let you respond because it's your motion, but you need to let Mr. Yalman-Chile finish his statements. Go ahead, sir.
I said that the evidence is not improper. I am making no personal attack on Mr. Cruz, but additionally, there are no grounds whatsoever for a mistrial based on this, which is properly authenticated and admitted evidence as a demonstrative aid, Judge.
All right, thank you. Mr. Cruz, anything further?
Absolutely, Your Honor. The Honorable Court, at the conclusion of court, allowed us the opportunity to view this demonstrative. The state, in multiple arguments, has insinuated that I have to run everything by them and then run it by the court. The law is the law. Regardless of how Mr. Yalman-Chile feels about me, the law is the law. This isn't anything personal. We're advocating. He says Mr. Foss did it. I say Mr. Foss is innocent. This should not be admitted without laying a proper foundation. It is admitted without a foundation. He's saying, hey, Your Honor, we're going to go through the questioning while we're showing the jury what the exhibit is. That's not the law, Your Honor. The law says that before they could present demonstrative evidence, they have to lay the proper foundation. That was not laid. The Honorable Court admitted it without even hearing us out on just denying our objection. So, Your Honor, Mr. Foss is not receiving his due process rights. I am requesting a mistrial.
Thank you, sir. All right. So first, I just want to respond, Mr. Cruz, to your comment that the defense is hamstrung, that the state has free reign. It is unfortunate that you are, as an attorney in this case, responding to the court's rulings in that way. The court certainly endeavors in every way possible to make rulings according to law. And it is unfortunate that you feel otherwise. That being said, you have asked for a mistrial. I'm denying that motion. There are no grounds for a mistrial whatsoever in this particular moment. This is a demonstrative aid. It has been admitted into evidence, but demonstrative aids do not go back to the jury. The state is correct. They did provide you the opportunity to see that demonstrative aid. They did not have to do that, but they did. You are mischaracterizing the court's rulings, Mr. Cruz, in suggesting that this court is somehow forcing you to show the state your hand without making them do that. That doesn't fit any of the scenarios in this case so far. And that is a mischaracterization that is pretty frustrating for the court to hear. There are no grounds for a mistrial. The state has properly authenticated this particular aid, and the foundation has been laid. There has been no violation of 403. I find that this moment has not even suggested that 403 is even in jeopardy. And I'm making a finding again that the evidence is, at this point, not improper. This is a demonstrative aid, and I'm denying your motion.
Judge Lott denied the motion for mistrial. Under the standard set in Monroe v. State, 2017, the proponent of demonstrative evidence must show that the conditions of the demonstration are so nearly the same in substantial particulars to the event at issue as to afford a fair comparison. Mr. Crew argued that the prosecution failed to lay a proper foundation and proceeded to publish the evidence to the jury prematurely. Mr. Yalamanchili rebutted this claim, affirming that Mr. Crew received the discovery file the night before. The prosecution's expert, ATF engineer Mr. Grove, used the PowerPoint as a demonstrative aid to explain his theory on the fire's origin. The prosecution argued that a simple exterior photo was a non-prejudicial starting point and maintained that the image was properly authenticated. Under Georgia's Rule 403, relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury. Judge Lott ruled there was no violation of Rule 403, affirming the state had provided the requisite foundation and authentication for the demonstrative aid. Judge Lott denied the motion, stating that a mistrial is an extraordinary legal remedy reserved for limited circumstances where the proceedings are so irreparably tainted that a defendant cannot receive a fair trial. On the following day, the defense renewed the motion for mistrial.
Your Honor, I am again moving for a mistrial. We can't impeach witnesses. We can't argue consent. The state can present things that we can't present. We can't rebut allegations in their indictment. We are requesting a mistrial. This is not fair. This trial has been worse than practicing in communist Russia. He doesn't stand a chance in this courtroom, Your Honor. The witness made a prior statement. We played the recording for the court. The witness made a prior statement. He was wearing like an orange-colored shirt, orange or red, something bright. That is a quote. We played the recording. The Honorable Court was able to hear that recording. Her testimony here today was that he was wearing a hoodie. This is important because the state wants to make all the people that were seen in the neighborhood Mr. False. The person that they brought the first witness in for said, oh, he had a jacket. So, of course, they want her to say, oh, he had on a hoodie. It's an inconsistent statement. We are handcuffed, Your Honor. We are asking for a mistrial in this case.
Thank you. Mr. Bolden, do you care to respond before I make a response?
Your Honor, Mr. Cruz has failed to make the proper foundation for a prior inconsistent statement. He has not asked the witness a question that the witness then denied. And so it's just not a proper foundation. So that's the basis of the state's objection. As to his motion, I don't necessarily think I have to make a response.
All right. Thank you, Mr. Bolden. So, Mr. Cruz, the first thing I want to say, and we are outside the presence of the jury, is that it is unfortunate that your constant comments about the unfairness of this trial it's very unfortunate. You know, it is outside the presence of the jury, but it is not appropriate to continually just argue to the court that things are unfair and that somehow the defense is handcuffed because of the court's rulings. As I stated before, the court endeavors in every respect to make rulings based on law. So that's the first thing. And, you know, having a slight tantrum every time you get a ruling that you don't agree with is really not appropriate. And I'm going to ask you to consider that moving forward. The second thing is the state is correct, Mr. Cruz, in terms of the procedure to request to admit an inconsistent statement, and you have not done it properly. I will say, for the record, in this particular moment, that your question was not the appropriate question to ask to recognize an inconsistent statement. It was kind of a trick question of sorts. You asked her to describe that particular piece of clothing, and her response was, I would say it was a hoodie, as if there was sort of the question allowed this witness, at least in my impression, to sort of pick, was it sort of a shirt or was it a hoodie? And the testimony, as I heard it, was that she elected to sort of describe it as a hoodie. If you would like to make an argument that in and of itself is what the law says is an inconsistent statement under the evidence code, then I will hear it. But if not, I'm going to sustain the objection and ask you to move on, sir. You may be heard, yes. And then I'll talk about the mistrial in just a moment, but go ahead.
If the honorable court has the statute, just save me a little time. I'm pulling the statute now, if that's okay. But if you have it readily available.
Well, I mean, Mr. Cruz, I'm not going to advise you on the law. And I think you need to be here prepared to argue it.
No, I just said if you had a copy of the statute. I was just trying to save the honorable court some time, but I'll pull it up here. The statute is OCGA 24-6-613. Prior statement of witness is the title of that section. Under subsection A, the law provides, in examining a witness concerning a prior statement made by the witness, whether written or not, the statement need not be shown nor its contents disclosed to the witness at the time. Provided, however, upon request, the same shall be shown or disclosed to opposing counsel. Your Honor, in this case, I went above and beyond. I actually chose to refresh her recollection as opposed to impeaching her when we were talking about her statement. She heard the entire statement. I told opposing counsel, this is what I have. They heard the entire statement. Subsection B provides, except as provided in Code Section 24-806, extrinsic evidence of a prior inconsistent statement by a witness shall not be admissible unless, first, the witness is first afforded an opportunity to explain or deny the prior inconsistent statement, which we did. I said, Your Honor, this is a quote. I read the statement as a quote. She said it was a hoodie. I confronted her with the statement, gave her opportunity. She still chose to say this was a hoodie. Second, and the opposite party is afforded an opportunity to interrogate the witness on the prior inconsistent statement. The state will have opportunity to examine her on the prior inconsistent statement.
Mr. Cruz, what is the statement you're saying is inconsistent with this witness's testimony?
Sure.
I think that's part of what the state was endeavoring to argue. So what is it?
So the written question that I asked, the individual that she saw walking, did she state he was wearing like an orange-colored shirt? She said that he was wearing a hoodie.
Well, that wasn't the question you asked, Mr. Cruz. The question you asked gave her an option to sort of describe what she meant. And you said something to the effect of, was it like a hoodie or a shirt? And she opined it was like, I'll say, a hoodie. I'm not sure that's an inconsistent statement, but I will let you question this witness again with specific questions if you would like to elicit the proper information for the court. I will let you question her right now out of the presence of the jury, and we can go from there.
Sure. In your prior statement in law enforcement, did you state he was wearing like an orange-colored shirt, orange or red, something bright?
Yes.
We can bring the jury back in. That's it.
All right. And, Mr. Cruz, I want to comment on your motion for mistrial.
Sure.
I'm going to deny that motion. The granting of a mistrial by the court is a very, of course, as you are well aware, extreme option.
Correct.
And it is done in very limited circumstances where the matters that have been presented in court are of such a prejudicial matter, such a prejudicial level that the defendant cannot receive a fair trial. And with regard to your motion, you have not sufficiently shown this court that that exists. And so I'm going to deny your motion.
Judge Lott again denied Mr. Cruz's motion for mistrial, finding that the defense failed to establish reasonable grounds for such an extraordinary remedy. Impeachment is the procedural mechanism used to challenge a witness's veracity. Under Georgia's Rule 801, a prior statement is not considered inadmissible hearsay if the declarant is subject to cross-examination and the statement is materially inconsistent with their current testimony. In accordance with the Georgia Evidence Code, such statements may be admitted as substantive evidence. However, Georgia's Rule 613 requires a strict procedural foundation. Before extrinsic evidence of the statement is introduced, the witness must be granted the opportunity to explain or deny the specific inconsistency, and the opposing party must be allowed to conduct a redirect examination on that point. Mr. Crew contended that the witness's testimony should be disregarded entirely due to a lack of foundational facts. Prosecutor Chris Bolden opposed this, arguing that Mr. Crew failed to lay the requisite foundation for an inconsistent statement. Judge Lott sustained the state's objection, ruling that Mr. Crew's use of open-ended questions failed to satisfy the legal standard for impeachment, which typically requires direct, specific confrontation regarding the prior statement. Following Mr. Crew's recitation of the statutes, the court reaffirmed its prior ruling. However, exercising judicial discretion to ensure a fair trial, Judge Lott permitted Mr. Crew a second opportunity to properly examine the witness. Ultimately, Judge Lott denied the motion for mistrial, reiterating that a mistrial is a remedy of last resort applicable only when the proceedings are so irreparably prejudiced that a fair trial is no longer possible. As of this date that we are writing the video, the case of State v. Faust remains pending adjudication. Our next case occurred in April 2025. Tamor Trayvon McIntyre, known as the rapper Tay K, stood trial in Bexar County for the 2017 shooting death of 23-year-old Mark Anthony Saldivar. Mr. Saldivar, a photographer, was killed in a Chick-fil-A parking lot in San Antonio after an argument escalated during what prosecutors described as a robbery attempt. At the time of the trial, McIntyre was already serving a 55-year sentence for a 2016 home invasion and murder. The case was heard in the 187th District Court before Judge Stephanie Boyd. Following a series of delays, the trial commenced in the spring of 2025. On April 8, 2025, Judge Stephanie Boyd reprimanded the defense team after they attempted to introduce damaging allegations regarding the victim's past during cross-examination.
All right, defense. The state filed a motion in limine. Defense, you were aware of the state's motion in limine. And I informed both parties, either side, if you have a motion in limine, before you enter into any territory that's the subject of the motion in limine, that you approach. And the reason why I do that is because, as both parties know, I do not know what the evidence is in your case. I don't know any facts of the case. I'm hearing this case as the jury is hearing it. And in the state's motion in limine, on page 2, it states, the state requests that the court grant this motion in limine and instruct the defense counsel to approach the bench and present the proposed evidence outside the presence of the jury before voir dire, opening statement, questioning, or in any matter bringing any witness or evidence of any of the following matters. And the number one thing says, any crimes, wrongs, or bad acts of the victim, Mark Anthony Saldivar. So, defense, it appears to the court that you violated the motion in limine, unless you're going to try to tell the court that possession of child pornography is not a bad act.
Your Honor, what I'm trying to listen to the witness.
No. The question is whether or not you were aware of the motion in limine, which you were, and whether or not you violated it in regards to violation of condition number 1. What you're trying to do with the witness, and excuse me, I'm going to have the witness step down. And counsel, you'll take your client to the back. You're still under oath and the rule has been invoked. And what I can tell you, unless you have some photos of child pornography that you're saying that the complainant had, then you're just throwing questions out and you're violating the motion in limine. It clearly states that you all are supposed to approach. Now, unless you all think that child pornography is not a bad act, then I don't know why that's a crime. Because if you're saying it's not a bad act, you asked this witness a question and it involved child pornography. Did I hear that incorrectly?
You heard that correctly, Your Honor, and I'd like to also make aware to the court yesterday when we approached about my motion in limine, the court specifically regurgitated condition number 1 to defense in regards to the nude photos.
Your Honor, I understand that the court is of the opinion we violated the motion.
No, not of the opinion. You violated the motion in limine. The motion in limine says that you are to approach before questioning or in any matter bringing any witness or evidence of any of the following matters. Any crimes, wrongs, or bad acts of the victim, Mark Anthony Saldivar. And you're asking this witness about whether or not he had child pornography or something in his camera. The court considers that a bad act.
Your Honor, to be clear, the questioning of the witness is intended to establish whether or not she previously made these statements. They're not being offered under Rule 613 for their truth. they're being offered for what she said to another individual. That
You are
contradicts her
still,
testimony.
what you're questioning her about is a bad act that she said that was the bad act of the complainant. And that's a motion in limine. And you all should approach before you do that. You violated the motion. The court is finding that you violated the motion in limine. And the only question now is how is that corrected? Because nobody approached the court to say, I'm going to start asking questions that is related to number one, to the state's motion in limine.
I understand the court's ruling. I've given my explanation for it. As far as a remedy is concerned, the court will do as it sees fit. I understand.
Oh, no, I am. But you're still, it appears to court, acting as though you haven't violated number one, and you have. You violated that motion in limine.
Your Honor,
And I can tell you, yes, counsel?
I think we're slightly, we understand the court's ruling. However, I do want the record to reflect, at least, that what we're asking is what the witness's previous statement. We are not accusing anybody of anything, and we're certainly not trying to accuse Mark, and we will be happy to explain to the jury.
It's still a violation of the motion in limine. Hypothetically, if somebody were to ask for it, any defendant, not just your defendant, if somebody were to ask a witness on the stand, hey, by the way, and didn't you tell somebody else that the defendant had possession of child pornography, the defense would be objecting because it's a violation of the motion in limine. It's a violation of the motion in limine in fact and in spirit.
Well, it is intended because this witness gave a number of prior statements. One to a police officer during an interrogation, which was video recorded. Another under oath before another judge in a different courtroom.
But here's the thing: it doesn't matter to the court. What matters to the court is that it's a bad act, and all you all had to do was approach the court. I would have heard it, what you are seeking to get from this witness, and I would have made a ruling on it. But instead, you have people who are violating rules, and I'm finding you violated the motion in limine rule. It's not supposed to be brought up until it's brought up to the court outside the presence of the jury. Now, what you have done is by bringing this up, I don't know if the jury's going to believe he was in possession of child pornography or not. I don't know if he was in possession of child pornography or not, because nothing has been presented to the court, and all you all had to do was approach the court and say, Your Honor, I believe we're going to go into number one of the state's motion in limine. And you know what I would have done? I would have had the jury step out, and I would have said, okay, what's the issue here? And you would have told me that, and I would have made a ruling.
Judge Boyd admonished the defense for a direct violation of a motion in limine, a pretrial order of which the defense had received formal notice prior to the commencement of trial. In Texas practice, a motion in limine serves as a protective order to prevent the introduction of potentially prejudicial or inadmissible evidence in the presence of the jury without first obtaining a ruling on its admissibility. The primary objective is to avoid incurable prejudice that cannot be remedied by a simple instruction to disregard. Judge Boyd confronted the defense team regarding an explicit allegation that the deceased, Mark Anthony Saldivar, possessed child pornography. The court clarified that condition number 1 of the limine order, consistent with Texas Rule of Evidence 404B, prohibited any reference to the victim's extraneous crimes, wrongs, or other acts without first requesting a bench conference outside the jury's hearing. Defense attorney John Hunter argued that the line of questioning was necessary to lay the predicate for a prior inconsistent statement under TRE Rule 613. However, under Texas law, the right to impeach a witness does not bypass the requirements of Rule 403 or Rule 404B. The court must perform a balancing test. If the mention of a victim's alleged bad acts creates unfair prejudice that substantially outweighs its probative value, it remains barred. Defense attorney Jerry Goldstein maintained that their objective was strictly procedural, intended solely to demonstrate that the witness was providing testimony inconsistent with prior statements. Judge Boyd rejected this justification, ruling that the defense's failure to approach the bench and seek a preliminary ruling constituted a willful violation of the court's standing order.
I believe this came up yesterday.
No,
Yes.
not the possession of child pornography.
The question of photographs on the camera of
Of nudes.
right.
That's it, of nudes. And when we were here at the bench, I even told to say, okay, he has nude photos, allegedly. I said, how is that a bad act? Having a nude photo is not necessarily a bad act.
I see what
And
you're saying.
both parties said, yes. Mr. Hunter, yes, Judge, you're right, it's not a bad act. And then we go a step further today, and now it's possession of child pornography. And I'm not going to allow you all to ask that question, and I'm going to instruct the jury to disregard.
We understand, Your Honor.
We understand. And there are some additional matters that she spoke of that have nothing to do with nudity or pornography.
And what would that be?
Your Honor, I don't believe that any other bad acts or potential bad acts of Mark Anthony Saldivar will be discussed other than those things which were discussed in opening statement related to the defense.
I'll determine whether it comes in or not. And you know why I'm going to determine whether it comes in or not? Because there was a state's motion in limine that says any crimes, wrongs, or bad acts of the victim, Mark Anthony Saldivar, you're to approach beforehand. And I need to make a ruling on whether or not it's relevant and whether or not it should be admissible. That's me. That's my job.
I understand your...
So what other acts or what other bad acts that you feel, crimes, wrongs, or bad acts of the victim, Mark Anthony Saldivar, that you feel this witness is going to be questioned about?
I can tell the court that it's going to be, and I don't know if it'll be disputed or not, that he damaged the vehicle. I guess that could be considered a bad act. I want to...
Well, with regards to the damage of the vehicle, allegedly, it said that he put his foot through the glass of the vehicle. That's a part of this whole alleged offense and the offense date. So, counsel, you all know that if there's evidence that's going to come in that he damaged the windshield, that's already in through other people.
Right, and the issue of what she said with respect to that to our client, she says that she didn't say anything. She looked straight ahead, didn't look to the side.
All right, so here.
May I just finish?
We're getting off track. We're with the bad acts.
Well, I'm going to suggest that she has told people, and I believe if she said race just of the offense, if she said something other than what she told the police officer, I believe that's a prior inconsistent statement, or entitled to ask her about it. It has nothing to do with pornography, sex, anything else.
Counsel, I'm not challenging anyone on inconsistent statements.
Okay.
I'm not challenging anybody on that. The court knows the rules of evidence. What I am saying is there's a motion in limine. And I think it's safe to say for the people who have been practicing even a year that you know you're not supposed to violate motions in limine. And number two, if there's an alleged offense and videos have been shown in exhibits that it's alleged to be, or maybe the jury feels it's already been established that the person who kicked in a window or damaged the window of a vehicle is the complainant, because witnesses have said it's the complainant who did that. So you all know, questioning the witness about that, that's really not about the motion in limine.
Right,
the motion in limine is about your co-counsel violating it.
My able co-counsel, I can tell you if I can get 5 seconds, I believe he will go into next the matter of what was said that precipitated the fight.
Right,
And I don't think it's about anything, and I think we're entitled to ask the witness.
Let me just tell you,
Yeah,
you violated the motion in limine.
we got that.
You will not ask this witness any questions about child pornography on a camera unless you have
We agree.
proof that there's child pornography on a camera.
Well, by the way, we do have proof of that, and it was a legitimate question. However, for the court's ruled on it. That's not what I'm discussing. I'm talking about what we're going to do next. And while I can't look into his mind, I presume since the court has ruled on it, we can make a bill later, but we're not going to do anything in front of the jury. However, I do believe conversations, what she tells the police officer, what she tells the judge, if there's somebody that says you said something else, I believe that's fair game, that's impeachment. And all I don't want to do is, we shouldn't have to have the hearing like this before we ask every question.
No.
And if it doesn't involve child pornography or some extraneous offense, I think we're entitled.
No, you all have to have a hearing because it's a part of their motion in limine.
Not
You can't
if it's
just-
not an offense.
Here's
Or
yes,
misconduct.
and the last time I checked, possession of child
I
pornography
would agree.
is an offense.
And we're going to be chastised and the court's going to do something.
Oh no, my chastisement is just stating the law. There's a motion in limine in place, and the defense has violated. And I am not going to allow you to ask questions about child pornography.
We're not going to do that based on the court's ruling.
Let's bring
However,
the
we
jurors
should
in.
be able to
Your Honor, just in anticipation, the only other aspects of this questioning that I believe will venture into territory that the state might object to would be questioning about whether or not she had a hand in getting the gun into Mr. McIntyre's hands, if that is in fact what happened. And secondly, whether or not she is the source of the marijuana, which I'm not clear on.
All right, so here's the thing. And let me just tell you, this is what I'm going to say this.
She was asked that.
This is what I'm going to say, and I want you all to listen to me clearly. Both sides have been practicing law for more than 2 seconds. Everyone here knows that if you're asking questions, and those questions are related to what's already been brought in evidence, the marijuana, it's already in there. It's already in the evidence. Who had it, what they did with it. Yeah, you can ask questions about that.
And guns.
The gun. It's already there. But I don't want any deflections where people are pretending as though they don't know that they violated the motion in limine. So I'm bringing the jury back in, and I'm telling them to disregard the last question. I'm telling them to disregard any testimony or questions about child pornography. Does everyone understand?
Yes.
And the defense, you violated the motion in limine.
Judge Boyd struck all testimony and inquiries found to be in violation of the motion in limine under Rule 404(b). Such evidence is generally inadmissible because it invites the jury to judge the victim for his character rather than the facts of the incident. Judge Boyd emphasizes that condition number 1 of the motion required the defense to approach the bench first, ensuring that any bad acts met a strict legal exception, such as proving motive or intent, before being heard by the jury. Defense attorney John Hunter attempts to bypass the 404(b) restriction, affirming his line of questioning as a necessary strategy to establish a prior inconsistent statement. But, in this instance, the probative value of showing a witness changed her story is secondary to the court's duty to prevent the jury from being misled by scandalous, unproven allegations. The legal admissibility of this line of questioning is governed by the Texas Rules of Evidence and Pretrial Orders, which mandate a good faith basis for any inquiry involving inflammatory subject matter. While cross-examination is a fundamental right under the U.S. and Texas constitutions, Texas jurisprudence grants trial judges broad discretion to limit testimony that lacks a proper predicate or violates a limine order, a procedural safeguard designed to filter out irrelevant or unfairly prejudicial evidence. Under TRE 404(b) and TRE 405, the court requires that any extraneous offense or sensitive allegation be supported by a proffer of verifiable evidence. Judge Boyd's ruling established that because the defense failed to produce a factual foundation for the alleged digital contraband, the inquiries were purely speculative and constituted a procedural default. Although a willful violation of a limine order can be grounds for a mistrial, Judge Boyd opted for a less drastic sanction. She issued a curative instruction, directing the jury to completely disregard any mention of child pornography and to not consider it for any purpose. By doing so, the court determined the error was curable, thereby protecting the record and allowing the trial to proceed to a verdict. On April 14, 2025, the jury returned a verdict of guilty for the offense of murder, a lesser-included offense of the original capital murder charge. On the following day, the court pronounced a sentence of 80 years in the Texas Department of Criminal Justice with no fine imposed. Pursuant to the judge's order, this 80-year term shall run concurrently with McIntyre's existing 55-year sentence, These cases underscore the pivotal role of the presiding judge as the gatekeeper of the court, tasked with safeguarding the procedural integrity of the trial. Both Judge Lott and Judge Boyd demonstrated that every courtroom exchange must strictly adhere to the rules of evidence and established law. Throughout their rulings, both judges enforced strict adherence to mandatory procedures, highlighting instances where defense counsel failed to meet the legal threshold required for their motions. By insisting on a good faith basis and the laying of proper predicates, the judges ensured that the defense operated within the bounds of the law, rather than relying on procedurally improper requests. Please share in the comments section below if there exists a legal matter or courtroom exchange you would like us to examine. We appreciate your time, and please remember to like and subscribe so we can continue promoting a better educated community.